Here is a very quick update, everyone, on the El Salvador case. Oh my gosh, with every filing, it's just fascinating. So, this is JGG versus Mr. Trump, and this judge is starting to get a little bit upset. So, let me just show you this order that just came out here. It says on March 18th of 2025, the court ordered defendants to provide by noon the following day specific information regarding flights carrying individuals subject to the court's temporary restraining orders issued 3 days before. Defendants instead, let me pull this out here. Defendants instead filed a pleading shortly before the deadline, seeking to stay the order in large part on the ground that they were considering whether to invoke the state secrets privilege. Although skeptical of the applicability of such privilege, the court granted defendants another 24 hours either to release the information ordered or to invoke the privilege. In an ex parte pleading delivered shortly after today's deadline, the government again evaded its obligations. It submitted a 6-paragraph declaration from the acting field office director for enforcement and removal operations at U.S. Immigration and Customs Enforcement's Harlingen, Texas field office. I wonder if it's the same guy that's been providing the other declarations. The contents of which the government has informed the court may be disclosed. After 4 paragraphs of identifying information, he repeated the same general information about the flights. On March 15, 2025, 2 flights carrying aliens being removed under the AEA departed U.S. airspace before the court's minute order of 7:25 p.m. Eastern and before the court's oral statements during the hearing. He then stated, "I understand that cabinet secretaries are currently actively considering whether to invoke the state secrets privilege over the other facts requested by the court's order. Doing so is a serious matter that requires careful consideration of national security and foreign relations, and it cannot properly be undertaken in just 24 hours. Again, this is the court. The judge is writing this. This is woefully insufficient. To begin, the government cannot proffer a regional ICE official to attest to cabinet-level discussions of the state secrets privilege. Indeed, his declaration on that point, not surprisingly, is based solely on his unsubstantiated understanding." That's the trust me, bro piece. Although its skepticism concerning the suitability of such privilege expressed in yesterday's order remains, the court at a minimum requires an official with direct involvement to swear that deliberations of the privilege's invocation are ongoing at the level Cerna attests. So it is the same guy. They basically have one guy who's writing all these declarations. Oh my goodness. I'm telling you, it's that one guy, this fella right here, who makes a determination as to whether or not you're in a Venezuelan gang and if you're going to be shipped out of the country. Just this guy right here. It further expects such deliberations to be concluded by March 25th, which only exceedingly good cause may excuse. Whoa, this is the language when your judge is super pissed off, everybody. This is the language here. In addition, to avoid further delay, the court will require defendants to show cause on the facts that they have already disclosed as to why the failure to return the class members aboard the 2 earliest planes did not violate the court's temporary restraining orders. Further supplementation may be required once particulars are ultimately disclosed. The court accordingly orders that, sorry, that was out of sneezing. Number 1, by March 21st of 2025 at 10 a.m., defendant shall submit a sworn declaration by a person with direct involvement in the cabinet-level discussions regarding invocation of the state secrets privilege. So Mr. Cerna needs to stop doing all the declarations. The court's saying he's not the guy that I want the information from. Number 2, by March 25th of 2025, defendant shall submit a declaration indicating whether or not the government's invoking the privilege. By March 25th, defendant shall file a brief showing cause why they did not violate the court's temporary restraining orders by failing to return class members removed from the United States on the 2 earliest planes that departed on March 15th of 2025. And 4, plaintiffs may file any response to such brief by March 31st of 2025. Signed, Judge Boasberg. All right. So this, oh my goodness. everybody. This is another step, another move in this chess game. Although the judge is playing chess, it looks like the government is playing checkers because they're not really. This Cerna guy's like, do. I'm going to do what I want. We're not going to tell you anything, Judge. And the judge is like, well, you don't have that level of authority. You have to tell me. We're walking slowly but surely, towards a pretty significant contempt situation. We are absolutely seeing the fight here between the executive branch and the judicial branch, which yet again, it is the judicial branch that decides whether or not all of this stuff that they're trying to invoke can actually be used. The judge decides if that privilege is appropriate. You can try to use it, but the judge has to make that decision. That's just how it is. If you want to use the privilege against self-incrimination, you set it out to the judge, and the judge says you can use it or you can't use it. I think people here involved in the government need to go back to the law school with the Law School 101 when it comes to, well, we're not going to tell you because of this, that, and the other. Who do you think decides this, that, and the other? Guess what? It's the courts. So we'll see how this unfolds. There's still supposed to be a hearing tomorrow at 2 o'clock Eastern time. And we're going to keep walking through this situation. Very interesting. And the judge is still getting pretty pissed off.